Assalamu alaikum and welcome to another edition of MLFA TV. My name is Khalil Meek, the Executive Director for the Muslim Legal Fund of America. And today our guest is Charles Swift, the Director of the Constitutional Law Center for Muslims in America. Welcome, Charles.
Thank you. Glad to be here.
Today we're going to discuss a landmark decision that just came out of the Supreme Court on January the 20th, a case titled Holt versus Hobbs, which has set a new precedent for religious freedoms and prison conditions around America. Today, Charles, you've had cases before the Supreme Court.
Yes, I was on Hamdan versus Rostow, which set an extraordinary precedent on presidential powers in Guantanamo Bay.
Well, then tell us about this case.
Well, Holt versus Hobbs involved a prisoner in Arkansas. He converted to Islam while in prison. His actual name now is Abdul Malik Muhammad. Okay. After converting, he desired to grow a beard of a half-inch of length because that's in accordance with the Prophet. The prison officials denied it. They had two reasons for denying it. They said, well, he might hide things in a beard that's half an inch long, or that he might be able to shave off the beard and somehow escape. So they denied his request for a beard, denied him. At that point, the Becket Fund got involved, which defends religious freedoms throughout the country, and they took the case to the Supreme Court. And in a 9-0 decision, the Supreme Court overturned both the District Court and the Eighth Circuit, holding that he did have the right to grow a beard.
So how did the court reach this decision to allow a Muslim to grow a beard?
Well, they looked at this case under a statute that had been passed by Congress in 2000. It's the Religious Land Use and Institutionalized Persons Act. And under that act, they said that government, whether it's state, local, or federal, must make accommodations both in the use of their land and for persons who were incarcerated to ensure that they enjoyed religious freedom. And they had put out two important tests. One, they said that if the person held a belief, then you should accommodate it unless there is a compelling reason not to do so. What the court found here is that what that means is that there's strict scrutiny. If we look at the two reasons that were given by the Arkansas Department of Corrections, they said, well, wait a second. Lots of prisons allow Muslims to have beards, so it's not really that much of a security concern. The other thing they said was, you could take a picture of him with and without a beard. There's not that much of a concern there. And when they took a look at the whole thing, they said, these aren't compelling reasons. They're not the least part. And so they struck down the statute under the...
When you say a compelling reason, just in general, when we're talking about religious freedom or religious practice in a prison setting, what does it mean to...
Well, what the court did is said that compelling is a very high standard. You have to have a real reason of security. For instance, if the individual had said, I want to use a knife to slaughter a lamb for Ramadan, or for Eid, excuse me, then the court probably would have upheld the prison forbidding a sharp knife to come in because they'd say that's a real security concern. There's a compelling interest in protecting the other prisoners and protecting the individuals.
But could a prison determine its own dress code or its own what would it be called, grooming requirements and apply it across the board and say this is our standard for our prison?
Well, that's the interesting thing. So they had argued that's what the Religious Land Use and Institutionalized Persons took on. They can do that. But what they also said is that they have to make accommodations for religious beliefs unless there is a compelling reason. So what the statute did was say uniformity in the prison is not a reason. The statute said you need to accommodate, that is, make exceptions for religious beliefs.
Where at all possible.
Right. And in the accommodation, whatever degradation on the religious belief has to be the least restrictive. So what they would say is a half-inch beard doesn't make sense. Now, maybe they could say a 5-inch beard we're not going to permit. And say but allowing some sort of a beard, that's permissible.
Okay. So what is the significance of the Supreme Court's decision in this case? Yes.
The
Why is it
real
important?
significance of the part is how they are now applying the statute. The year before in the Hobby Lobby decision, they looked at another religious statute. And what it showed us is that the Supreme Court is now applying a very strict standard to government actions that implicate religious beliefs. The Supreme Court is now very strongly, this was a 9-0 decision, in favor of the religious rights, both of if you want to think about the people who have the least rights, those incarcerated, and in other areas. So what it tells us is that the court is going to interpret on the individual side far more likely than on the government side, absent compelling reason. And what it sets is a precedent that these sort of fictitious arguments that are often put forth by the government are not going to be accepted by the courts any longer.
So they have to have a compelling reason.
That's
Now,
correct.
does this case apply outside the state of Arkansas?
Absolutely. The statute that was in play is a federal statute, and it applies universally across the United States. And given that Arkansas couldn't give a compelling reason for a beard, it is extraordinarily doubtful against a beard. It is extraordinarily doubtful that Florida or some other place could come up with one.
Excellent. So what if a prisoner was previously denied the right to have a beard? Can they now sue regarding that denial?
Well, it depends. Well, first off, just to understand that the statute doesn't provide for money damages. In other words, hey, they denied me a beard, I can sue and get some money. No, you can't. If they still maintain that denial, then of course you can sue. And just because you've asked in the past, this is for any prisoner who would like to grow a beard or other religious accommodations that have been previously denied, in light of Holt versus Hobbs, they should renew that request.
So, like any other, like this case was specifically about growing a beard.
Right.
But the interpretation of the law was a much broader interpretation.
That's correct.
Which said that other religious accommodations, such as meals during Ramadan, would fit into this ruling. In other words, the Muslim Legal Fund receives a lot of complaints from Muslim prisoners all over the United States, saying that while they're observing their religious obligation to fast in Ramadan, their meals might be either served at a time when they can't eat it and taken away from them before they're allowed to do it. So how would this ruling affect other religious accommodations?
It didn't address any of them. That's normal for the Supreme Court. However, the logic that was employed by the court almost certainly would also dictate that accommodations be made here. It would be very difficult to come up with a compelling reason on a prison why you can't serve meals to someone after sunset or before sunrise. Certainly accommodations can be made. And that part where they said the least restrictive means also part of what the court used in its analysis would probably drive this. Many institutions, including all federal institutions, accommodate Ramadan and accommodate halal meals. When we've seen those complaints, most of the difficulty are state jails, state prisons, etc., which are counties are far less accommodating. The fact that it's been accommodated elsewhere, the court found to be a compelling factor. So on things like Ramadan meals and those sort of things, it is very likely that a federal court would require the jail or the prison to make the accommodation.
So the prison would have the obligation of producing a compelling reason why they can't, not just saying they don't want to.
That's exactly it.
So based on this, does the Constitutional Law Center for Muslims in America plan on taking cases on behalf of Muslim prisoners that are being denied religious accommodations?
We do. We're hopeful, of course, everyone I think should be hopeful that in light of the decision, the prisons will get the message. Our experience with prisons, however, is that they don't get the message. And so if a prisoner has a suit where they believe they're being denied an accommodation, the first thing they should do is write a request. What's important on this is that, for the suit to be right, is first you got to ask, and you have to be denied. So they need to make the request for the religious accommodation, whatever it is, and they should make it in writing, telling guard so-and-so isn't sufficient. Put it in writing. All prisons have methodologies for making these requests. Put it in writing. Or their family members should put it in writing, someone. And then if it's denied, then what we would urge them to do, them or their family members, to contact the center. And we'll then look at whether we can simply get the prison, inform them of the law, perhaps change their minds before we have to file suit. But if the prison's unwilling to change, and they can't provide a compelling reason in our judgment, then we're going to file suit on behalf of that prisoner.
Well, this is excellent news for not only the Muslim community, but for religious freedom in America, and especially the way prisoners can be isolated from the public, isolated from others that have a restriction put on them of protecting their rights. This decision will allow organizations like ours and others to stand up for them in court and compel performance by local institutions.
That's correct. And I want to add one thing onto that. What's important part is, there aren't a lot of Muslims in jail, thank God.
Mm.
But you need to think about what the statute said: religious land use and institutionalized persons. Far more Muslims are facing some form of discrimination in local zoning laws that suddenly apply that they can't have a mosque, or threats to deny the use of a school or that sort of thing because of their religious beliefs.
So thank you, Charles, for being here with us today and sharing with us how this new landmark decision affects not only Muslims but all religious communities across America. We appreciate you spending this time and giving us that valuable information. And I want to thank you, the listeners and the viewers of this program today. We hope that you liked this presentation, and that if you did, you would share or forward it to others on your social media networks. We also want to let you know that the Muslim Legal Fund of America is a charity that is here to defend Muslim rights in court, and that the work that we do funding the Law Center for Muslims in America, for Charlie being able to take cases to protect Muslim rights, is all made possible by you, the generous donors of the Muslim Legal Fund. So we encourage you to continue that support and visit our website, mlfa.org/donate. And with your help, inshallah, we can and will make a difference. Thank you, and assalamu alaikum.